an extremely urgent motion. Kindly seize this notice. Eviction on the 20. I've been asked to go by 27th. Eviction is on the 28th. Lordship, the notice does not even have a date. We were served, some of us were served on the 17th, some of us on the 18th. And there is already a subsisting order of this honorable court that we cannot be evicted without due process of law. Lordship, I was humbly seeking your Lordship's leave so that I can get it affirmed today. And
tomorrow. My lord.
Lordship, may I get tomorrow at his Lordship fixes the time.
Will appear tomorrow. My lord.
May I get the leave?
Yes, yes. My lord, under compelling some circumstances, my lord, I'm paying for my lord's leave on the same point. Undated and unsigned notice has been given for my lord eviction. If no, leave is required, my lord. Yes. Tomorrow. Yes. Great. Kal.
We are for the respondent number 1, my lord.
What I undertake to
For the petitioner.
Respondent number 1. We are appearing for respondent number 1. Union of India, my lord.
Union of India.
Yes, my lord.
Yes. What is this matter?
well, this is seeking compensation. The National Highway Authority has acquired my land without initiating any proceeding, any compensation, my lord. Well, if your lordship kindly turns to page 44, I have given a picture. Page 44, the portion of the land, according to me, it's 4.56 decimal has been acquired.
What is the representation? Removal of encroachment?
No, this was a combined. I have pleaded in my writ petition. That writ petition has been disposed of, directing the authority to take appropriate steps for removal of encroachment. And if your lordship kindly turns to
Removal of encroachment by others.
yes, by others, that writ petition has been disposed of. This was a combined representation. That,
Yes.
well, if your lordship kindly turns to page 46, paragraph 3. The frontal portion of the said land had been taken over
Yes.
by the National Highways Authority of India for the purpose of widening and development of the said national highway. And the last paragraph that appears at page 48 last.
Yes.
It is therefore most humbly requested to appropriate step against such and such, and then my lord have say obstructing my ingress and egress, and also to cause an inquiry to the appropriate authority to ascertain the extent of land belonging to me that has been taken over and ensure payment of due compensation in accordance with.
Yes. What is your instruction?
My lord, we are for the. But we are not the answering respondent. National Highway Authority is the answering respondent, my lord.
National Highway Authority, have you served?
Malas, I have thought, Malas, I undertake to affirm the affidavit in opposition. The Xerox copy is with me. Malas. In course of day, I can find.
Who will consider this representation?
Malas, I'm told the respondent number 7, the assistant engineer.
Assistant engineer?
Respondent number 2.
6 question.
National Highway Subdivision.
7 হবে।
So it's the state authority.
Yes, my lord. State authority.
টাকা দেবে তো ন্যাশনাল বেশি মাঝখানে কথা বলুন না
National Highway
ওনার রেসপন্ডেন্ট নাম্বার 2
Number
2 ন্যাশনাল হাইওয়ে অথরিটি ওদেরকে সার্ভিস
the authority of the National Highway Authority. If it relates to compensation, it's the competent authority. That is the additional district magistrate.
রেসপন্ডেন্ট নাম্বার 6
It's the state authority
kindly keep it after that
after vacation.
State is the
The learned advocate appearing
My lord,
combined everywhere. Please file a fresh representation. File a fresh representation, they will consider.
my lord.
Who will be the appropriate project director?
My lord, the project implementation unit, my lord, project director.
কি, ওটা কি বলেছিলাম? Yes.
For reply
Union of
number
India is represented by the respective law and order.
হ্যাঁ নাম দিয়েছি সুমন
Yes, yes,
চট্টোপাধ্যায়
on the next
ট্রাফিক
matter,
reply number 1.
But I am for the petition.
Yes, Lordship, I am for the respondent,
For the matter relates,
8 to 11.
matter relates to illegal encroachment on PWD land. But earlier occasion, the father of the
so
petitioner.
the state is not here.
Yeah,
You are for the state,
Yes, Lordship, and
for
the,
the state.
yes,
Yes.
I am the respondent number 8 to 11.
Comment number
8 to 11.
8 to 11 are private
Private,
respondent.
Private respondent.
not state.
You are for the
No,
state. you
no,
said
No,
yes.
no, no, I'm not. I'm the private respondent.
State is not here
But
after vacation. Now, five.
I am for the petition. Yesterday, my lord was pleased to direct me to serve notice upon the office of the government pleader. I went there, but panel has
After vacation,
after
yes.
vacation. Yes.
Item number three.
For the petitioner. Well, it's not, I have got the instruction to appear on behalf of the private respondent yesterday night, but till now I have not disturbed.
After vacation.
Only thing, my lord, if my representation be considered after hearing of
State
both
is
the
not
parties.
here. The state is difficult. Yes, next. Item number seven.
Wait,
Number seven. Pass over next.
Eight, my lord, yesterday notice upon the GP was served.
Who has been engaged?
Well, that information is not available, my lord. But my lord, kindly sees, my lord, the stamp. The office accepted my notice.
Yes, Mr. Banerjee, only yesterday, some of the officers have been appointed, not the entire panel. So
But I'll come back, my lord, after vacation then. my
you
lord.
have instructions that someone has been,
Eight. State.
you are for the state.
Mr. Leandro Bhattacharya is appearing in court number 1.
You are also,
Praying for a very short password.
what is this matter?
My lord, illegal encroachment, my lord.
Consider that. Take a
Yes.
decision.
Brother, every day service to the other one.
Where is Mr. Bhattacharya?
A matter is running in court number 1, my lord. A matter is running in court number 1. I'm praying for a very short password, my lord, so that he can.
He has made a representation. Consider that. Take a decision.
My lord, page 42 is my representation, my lord.
Private respondent, Mr. Banerjee.
Yes, served. Copy has been served. All
Or when? When they have received?
my lord, this was a new motion, my lord. Dada, ekbar deben.
When they have received, I am asking you.
Yes, I'll just indicate. 15/5/26.
Petitioner claims to be the
9, my lord, I'm praying for, my lord, after vacation, my lord. The copy is yet to be received, my lord, by the private respondents.
Not a good matter, even before the.
No, my lord.
Yes, yes, yes. Din.
My lord, I am appearing for the
I'm,
national.
my lord, praying for an adjournment on behalf of Mr. Maithi, my lord. Well,
What is this matter?
But my lord, removal of encroachment. my lord.
Yes, encroachment from National Highway.
My lord, that is the
So DM is the
my
appropriate
lord,
authority.
my lord, my
Have
lord.
you
This
submitted
seems that is the
resolution before the
notice. my
DM?
lord. Is the lordship
I'll
that
just-
is
I'll just-
notification?
I'll just, my lord.
Private respondent served.
My lord, private respondents, my lord, it's pending, my lord. Copy sent, my lord, they are yet to receive. That is my instruction.
The learned advocate appearing for. Yes, the article be.
And in this matter, my lord, I am for the Union of India, my lord. Actually, my lord, I am for the Union of India, my lord.
Union of India. Yes, who is for the petitioner?
I'm for the petitioner.
Who is the answering respondent?
The
State
respondent
or
number
Union of India?
1, Union of India.
Union of India.
The
Yes.
general
yes,
manager is
but-
the appropriate authority. Previously, I moved application and kindly have a look to page my lord 30.
Yes, what is your grievance?
My lord, they have not paid any compensation and land user certificate.
Compensation. Yes, what is your instruction?
My lord, I have no instructions, my lord. I have no instructions, my lord.
But the
Is
page
in possession
35,
of the property or not?
But till now, my lord, I have no instructions.
I have been in position, but at present, my lord, they have started construction work of railway line. So
Construction made.
going on.
Going on.
Yes, my lord.
They are keeping it after the vacation. Let him take instructions.
Yes.
Let's call the next matter.
My lord, I am appearing online, my lord.
Yes, Mr. Mujumdar, who is the answering respondent?
My lord, the answering respondent is the Municipal Commissioner, Howrah Municipal
I appear
Corporation.
for the Union of India.
Corporation, then how can it be group one matter?
No, it has to be because he has exercised powers under the West Bengal Inland Fisheries Act. Persona designata.
Land Fisheries Act.
Yes. My lord, my lord, there is a suit pending
He is appearing for
between
Howrah Municipal Corporation.
Service competitive.
Service, my lord.
Banerjee,
Sandeepan Banerjee appears.
can you bring him?
After vacation,
Don't I can intimate him, but
When have you served upon the
they have received, my lord. The track reports are there.
because the board is not functioning also.
19th May.
That is also a difficulty.
19th May they have received.
So, my lord, will your lordship keep it tomorrow or my lord, so that
Today
we
I'm
can.
passing it over at 12.
My 12, Mr. Banerjee will be here, my lord. I will be in some other court, my lord. I'm out of
Prayer
station
for
actually.
dispensation, my lord. Kindly, but there's prayer for dispensation of service also. We have sub
My lord,
not appearing.
Yes, what is this matter?
my lord, I tell your lordship, kindly come directly to page 36.
Yes.
Your lordship will find this is an RTA application which we took out because my lord, we found that our possession is being interfered with respect to DAG numbers 280 and 284. So, my lord, in response to the RTI, in
83.
my lord, DAG number 236 is my RTI application, And the response to RTI is there here. Well, kindly take first page 33. But this is a writing from the assistant engineer Baro 8 so and so to Commissioner of Police, Howrah Police Commissionerate, alleged illegal filling of water body in so and so tag number 279 RS, 283 and 284 LR. Now, well, 279 RS, yes, 283 and 284 LR belongs to me, and there is no separate existence of 279 RS because 279 RS is now 280 and 284 LR. We have sale deeds.
280 or 283?
83.
280 and 283. 283 and 284. I'm sorry. 283 and 280. I'm sorry, man. I'm
Correct.
so sorry.
According
So-
to you, though there are three numbers in effect, now 283 and 284 are the current.
At the existing numbers, my lord, the existing
Yes.
numbers. So, my lord, what happens, my lord? I purchased these lands, and there are sale deeds to that effect. But the details regarding the sale deeds I have disclosed in my application, in my writ petition at paragraph 2.
Yes.
Now, my lord, I believe Mr.
Are you-
Banerjee.
Are you filling up the pond?
No, my lord, it's a Sali land as per the ROR. Kindly take the ROR. ROR starts at page 16.
Where is your purchase deed?
Purchase deeds, my lord, I believe, my lord, Mr. Banerjee is carrying some of the purchase deeds.
Mr. Banerjee, you have the back deeds also.
My lord, the
purchase
trail
deed
deed,
of
my
your
lord,
vendor.
the
Purchase deed of your vendor.
my lord, I have an injunction in my favor from the civil court. My lord, this is at the instance of two promoters who are interfering with my possession. I have got an injunction from the civil court. Your lordship will also find the injunction at page 8. It is page 28. Now, my lord, when they could not do what they could not do directly, they are now trying to do indirectly by influencing, my lord, the commissioner, Howrah Municipal Commission, Corporation, and by invoking the provisions of the Inland Fisheries Act. Because there is no other provision in the HMC Act in so far as, my lord, the land in question. It's not a question of building.
So what is the civil suit for?
But the civil suit is for declaration regarding my possession. Kindly take the civil suit. My lord, the plaint, I believe, my lord, Mr. Banerjee may be having. If you lost.
Municipal Corporation. Municipal Corporation led by Mr. Sandeepan Banerjee.
So, my lord, my learned friend is there. My lord, kindly take, my lord, the operative part of the injunction, which is at page 29.
Mr. Mujumdar, this is with regard to injunction relates to possession and enjoyment.
Right,
Nothing
right.
with regard to the nature and character.
My lord, the nature and character
Does
would
not
be
relate
evident
to the
from.
nature and
Yes,
character.
yes, my lord. The nature and character would be evident from ROR. Kindly take the ROR. Record of rights, which is at page 16. Your lordship will find Sali and Sali. There is no, my lord, any my lord, indication that the plots in questions are water bodies. Page 16, my lords.
Yes, yes. Yes. What is your instruction?
Without jurisdiction also.
Lordship, I
Why
have to
without
check.
jurisdiction?
Commissioner is the competent authority. He has not issued.
Commissioner is the competent authority that your lordship will find the relevant notification being the last annexure to this writ petition. Under the inland.
Commissioner, now who has issued this notice?
Assistant engineer.
Assistant engineer.
Lordship,
Well,
I have to
this-
check instruction from corporation.
It was served, I believe, on 19th. And today we are on. Kindly take the notification, my lord, which is at page 37.
Yes, notification. Yes.
Your lordship has seen the notification. So, my lord, today the land in question is indisputably Sali. So, there is no requirement of 4C and all that.
Yes.
My lord, I am in possession.
My lord, I have photographs to show.
Who are you?
I'm the private respondent. I'm the complainant, my lord. I own the adjacent plot of land, my lord. I have my lord, sought a series of complaints to various authorities. I have photographs to show, my lord, how.
What is the civil suit?
Yes, my lord. My lord, I have photographs to show, my lord, that a water body is being filled up. Kindly see along with dates. I have underlined the two dates, the two pages that are folded, my lord. 26th and 30th. 27th and 30th. That is the 30th photograph, my lord. I have, and kindly see, my lord, the water body is visible. On the other folded page, which is of 27th, water body is visible.
Mr. Banerjee, what is your instruction?
Well, my instruction, I have to have a copy first.
Copy has been served, Mr. Banerjee.
So then I have to call for a copy because copy has not come as yet. Some problem is going on. In fact, I have to call for a copy, man, it will come. If your lordships give me some time,
Happens that you have issued a notice.
my lord.
So, who is the appropriate authority to
In
issue a notice under the Inland Fisheries Act?
Commissioner,
Who has issued this notice?
I have to have a copy, my lord.
Mr. Banerjee, please give him a copy.
But there is an error of jurisdiction, my lord, as indicated by your lordship.
He notices for the punta.
Assistant engineer.
Page 33.
Page 33. No, it's an engineer.
Then
I
But
don't
this
know
has
whether-
to
how
go,
can
my
they
lord.
de- How can it be delegated also? I don't know, my lord.
setting
Well,
aside, so if the
Yes, yes, my lord.
authority
Only
can
one
just
thing,
say
my lord. May I have a copy?
that's without jurisdiction.
I know. I and see at my face itself. But even then also, can I have a copy for today itself? I will come tomorrow. Online online এ থাকো
1
কপিটা
p.m.
পাই
1 p.m. Because
One-
this is the Mr.
1
Banerjee,
p.m.
please give a copy right now. Please give an extra copy right now. Because
copy টা
this
নিয়ে নেবো?
empathy is without jurisdiction. So
Commissioner
I
is
leave
the
it-
appropriate
I
authority.
leave it open to the authorities to initiate steps by
Yes,
the
my lord.
appropriate.
Let it be so, my lord.
Record my record my name. I have appeared.
Yes.
Grateful, my lord. Grateful.
The,
But may I take your lordship's kind leave, my lord?
thank you. Yes, the petitioner. Points are এখানে। Count it করে দিয়ে। Yes, next.
Your Lordship, 12, 13 are similar matters. I'm praying a day's accommodation. Let it appear tomorrow because I still don't have the brief.
My lord, 23rd is my date of, my lord, the eviction, my lord.
But tomorrow I'm praying, let it be taken up tomorrow, Your Lordship.
What eviction?
My lord, the railway authority, my lord, issued notice. I am lawful tenant, my lord. My lord,
Lawful tenant under railways?
No, not at all.
lawful
Under
tenant, under my lord, the Hooghly rivers and my lord, the Hooghly Nodi Jalapath Parivahan Samiti, my lord.
Not a state under Article 12.
My lord, yes, state sponsored, my lord, kindly come. My lord,
State-
my lord, state sponsored organization.
নদী জলপথ পরিবহন সমবায় সমিতি লিমিটেড is a state under Article 12.
State sponsored, my lord, organization. My lord.
Sponsored is.
That's
does
true.
not-
But my lord, what happened here, my lord, from
Your
2000,
grievances against this authority.
no, from 2016, 18, 17, my lord, kindly take up item number 12, my lord. it will be
Item number 12. বারোটা দিন। 11676.
116.
Yes.
Pawan Sonkar, my lord.
Yes, yes.
My lord, kindly come to page, my lord, 11 first, my lord.
11, yes.
My lord, the page 11 is the, my lord, I have been given, my lord, the permission for, my lord, the business by that authority. And even, my lord, there are correspondence between this authority with the railways. And my lord, informing that he is the tenant. My lord, kindly come to that.
Included হুগলি নদী জলপথ.
Yes.
You are the tenant under হুগলি নদী জলপথ.
Yes.
The said that authority is not aggrieved by the action of the railways.
My lord, say they have not, my lord, approached before this court, my lord, by my lord, kindly come to 146. My lord, kindly call 146.
Structure is owned by whom?
By me.
Structure is owned by
My lord,
you.
my lord, that land was given. This is a small, my lord, the shop, my lord, that is going on. From 2016, every month, my lord, you used to pay rent, GST and other. But to, my lord, this Hooghly Nodi Jalapath, then they used to give to the railway. My lord, kindly come to page 146.
They used to give to the railways.
Railway,
Please
146.
show me that they used to pay to the railways.
That is, my lord, not payment. My lord, 146, my lord, the correspondence between railways and the, my lord, kindly. 146. 146.
146.
My lord, page number one.
Only 46.
146, my lord.
146.
My lord, perhaps
Contains only
146.
only 48 pages.
No, that is second one, my lord. That's why I'm doing this one.
কোনটা দিলেন?
This is my lord. I'm giving.
Item number 12 is this.
12 and
11676.
I'm saying 13, my lord. 13. My lord, kindly see this one.
13 এর right আছে, 13 এর right আছে।
আছে তো extra copy দিয়ে দাও।
আর কপি দিচ্ছি।
Yes.
And my lord, see the impugned notice. 146, my lord, this is the correspondence in February, in this month, my lord. In this.
Somebody is writing to railway. How can this?
No.
Has the railway written it?
This is
them?
correspondence with railway, and on reply they have to, my lord, say so. And my lord, kindly see the next page is, my lord, the notice, undated, unsigned, my lord, a notice. Therefore, my lord, and IRCTC and railway has
No, this the Hooghly Nodi has written to
railway.
senior divisional manager.
Railway. My lord,
So does it mean that there is a relation between with the railways with that
my lord,
authority?
so far my humble submission, subject to lordship my lord, kindly consider that the next notice is the, my lord, next page. The notice is undated, issued by, my lord, the unauthorized any person, my lord, nothing has been said, but who has been issued. My lord, I am the occupant there, my lord, and my lord,
Under whom?
my lord, under the Nodipath, my lord, under the Nodipath, and my lord, I am paying rent
That
without.
authority is not is not evicting you.
My lord, my lord, that's true, my lord. But my lord, without giving any opportunity of hearing and others, my lord, suddenly, my lord, this notice has been
Did
given.
you enter by notifying the railway authorities?
My lord, this is the.
I'm asking you, did you enter by intimating the railway authorities?
My lord, because my lord, they have given me my lord, the permission. I am carrying the business from since 2016.
To that authority.
My lord, through this Nodipath authority,
You
my
will
lord.
claim damages.
My lord, this is the situation, my lord.
You can sue that authority.
My lord, kindly consider.
But these railways cannot be made responsible.
My lord, the railway authority, my lord, without, my lord, they can issue me notice. My lord, they have not issued any notice. My lord, kindly see this notice 147.
If I issue you notice, I
147.
recognize you.
Not necessary.
One
Under what
provision
provision they will give you notice?
My lord, If,
Under what provision?
my lord, so far, my lord, be subject to lordship, kind
Asking you
sanction.
under what
My lord,
provision they will serve notice?
Under my lord, unauthorized occupancy, my lord, if I am unauthorized occupant, my lord, this also I am claiming that I am lawful tenant. I am not unauthorized occupant. My lord, so far,
You are
my
not
lord,
a lawful tenant under the railways.
Railways.
My lord, can you say that you are a lawful
my lord,
tenant?
by my lord giving the notice, my lord, my lord, and evicting me, my lord, giving me opportunity of Article 21, my lord, instead for the nature of justice also.
If
I
encroach
can
upon the public property,
no,
then the notice will be issued, giving you an opportunity.
subject to lordship, kind sanction, my
It's difficult to digest.
subject to kind sanction, my lord. This is
Article
not, my lord.
21 cannot be stretched that far.
This is not, my lord, the totally, my lord, the encroachment. I have not encroached anything, my lord. What I have done,
If you have not encroached, you will not be removed.
my lord,
I will restrain them from
my lord,
demolishing anything beyond their property.
my lord, what I have done,
That they cannot do.
what I have done, my lord, instead of, my lord, that
You have not encroached upon their property.
my lord, kindly see from last 10 years, my lord, I am paying GST. I am paying, my lord.
Your lordship, kindly take it up tomorrow.
Unauthorized occupants, sir. This notice has to be issued by the state officer. Unless state officer issued the notice, railway is also having their state officer. That notice has to be issued. Number one. Number two, your lordship knows the Great Eastern case, 2002-5. This is the way of eviction is not recognized by law. Also 61 Supreme Court, the eviction or etc.
Bandhavata, you are also aware there are some coordinate based decisions. The railways.
No,
There's a Supreme Court order as well.
Section 147.
No, 137
of the Railways Act
137 cannot be read without giving any opportunity of
Your
reading.
lordship, a Supreme Court order is there.
প্রচুর instruction আছে তো তোমার
হ্যাঁ,
তোমার instruction আছে
হ্যাঁ,
then you are
There,
then you are
your lordship, there is a Supreme
then you
Supreme
are. I
Court
will-
order as well, which says that all unauthorized has to be removed.
Notification.
All unauthorized occupant has to
No,
be removed from railway property.
there is no I will show you
Supreme Court order.
give it
We have
tomorrow
to
I
put
will
it
show you to your lordship bulldozer justice is an unconstitutional. Supreme Court has said in recently 2 judgments. This is cannot be done. Even if you have a right, no, if I don't have a right, no right. But he is saying, I have not read, I was hearing is, firstly, he is a tenant of some state authority.
No, not the state
Please.
authority.
This is the way I don't argue with this.
Yeah.
Madam, you may be very good lawyer, I am not. I am very small lawyer.
Me too, sir.
No, you are very
Small,
good
very
lawyer.
small
No,
lawyer.
why you are interrupting? Is it the practice? Go to Supreme Court. There is scope to interrupt, but not in High Court. Now let's see. First of all, any affected person has to be served notice. A right of hearing is a sine qua non of Article 14 of the Constitution. Number 2, power has to be exercised in terms of the statute. Your lordship is saying Railways Act. Railways Act, I have argued the points, my lord. There is a judgment is there. And I argued before Justice Sabyasachi Bhattacharya. And I got the order.
Referred. A point of reference has been made. It has been referred before a large judge.
No.
Yes, what is this judgment I have considered in one.
Yes, your lordship.
Same
Few days back, your lordship had passed it on.
Whether the railway authorities can evict by in exercise of the powers under 147(2) without taking recourse to the 1971 Act.
That's a different. I am saying this reference, but we not decided. Railway Act appoints a state officer.
Section 5.
Section 5. Section, I am just telling a lots of the scheme. Railways Act appoints state officers. State officer has to decide whether it is an unauthorized or authorized. Right? If it is unauthorized, then the power comes to evict.
Then Section 9.
Then he is having a power to right of appeal.
9.
Yes.
Therefore, 2 powers cannot be curtailed in this way. These are both of the 2 powers. Lordship knows the Olga-Tellis case. That is 1986, AI 1986 180 SCC. There has been clearly said it's a violation of Article 21 of the Constitution. Although there was an undertaking, I am telling you, Lordship, is a fact if I remember correctly. Bombay Municipal Corporation wanted to evict That time the all stall owners gave an undertaking that within 1 month, we will leave it. And then again, within 1 month, they wanted, then they moved to Supreme Court in Article 32. There is no undertaking which is contrary to law. Cannot exist.
And my lord protected base risk.
Just a minute. And let me talk about law. This is, they cannot lay down. Therefore, firstly, if there is a statutory provision, one has to go by the statute. What your lordship is saying, whether 137 has been referred to, that has to be decided. That's a different thing. But today, what is the law about?
One of the matters that has been referred.
No,
In
I'm not
On
saying no.
19th, your
I'm
lordship had
I'm not
passed that
saying
order.
no. But by
On
making,
19th of this
by
month.
making the, because of the reference has been made, law has not been changed as yet. If the higher court says no, 137 is separately can be exercised. Even 137, my lord, why the natural justice has not to be implied, read to be implied. 85 Supreme Court, Tulsiram Patel's case. What is the urgency that the natural justice has to be violated?
Yes, madam, you have instructions.
Your lordship, I was humbly praying.
My lord, my friend, my
Let it,
junior
let it
friend
appear
has-
tomorrow morning,
my lord, my junior
both
friend
the
has-
matters.
my junior friend has said by, but I was sitting here, that your lordship has.
Same order which your
That
lordship
is
was
the base-
referring.
base
Yes,
risk.
yes, I'm aware of
That-
that.
Therefore, these are the
But there the facts was something different. Because I've also considered the decision of the Honorable Supreme Court. There it relates to, in that matter, it relates to a large number of families. Where this was done. So in one matter, the Honorable Supreme Court has directed, has requested the state and the railway authorities to
Formulate a
sit together.
scheme and see that they are rehabilitated.
And rehabilitation scheme can be evolved or not. So I've considered that. I'm
That's all right.
aware of.
Now the point is this. These are the.
There also I've noted the decision of Justice.
My lord, just I will
referred to.
not be here. Otherwise, I could have assisted your lordship. 61 Supreme Court, Bishan Singh's etc. judgment is there. Number 2 judgment is the Great Eastern Hotels case.
Tomorrow, madam, can you?
Yeah,
Your lordship, tomorrow.
number 3 judgment kindly.
My learned
eh,
friend could
kal ka
provide
judgment will do.
quoted
Kolkata Tele's case.
item 11's
Number 4 Pista Devi's case. 86 4 SCC. Pista Devi's case. Pista Devi's
Tomorrow
case
I'm keeping it.
principally has said
early
these
morning.
words long back. And one thing kindly, my lord, 2 judgments are there. One is Justice Chandachud judgment. And another one judgment is Justice Oka's judgment. But the Puldeja justice is an unconstitutional, has been said.
Yes. Tomorrow.
Tomorrow.
The learned advocate.
Item 11 at the
appearing,
Supreme Court.
heard the learned advocate.
Samavay Samiti হয় না তো।
Somiti Limited.
Samavay Samiti.
Sponsored by Government of West Bengal.
Sponsored by Government of West Bengal. Therefore, Article 12.
The learned advocate appearing. They are appearing.
12 and 30. 12 and 30.
Yes, next. Mr. Bhattacharyya is appearing in that. 12 and not 13.
Same matter, 12 and 13, similar matter.
Ask Mr. Bhattacharyya to appear in that also. He is not. Yes, call the next matter.
My lord, I am appearing, my lord.
Thank you. Thank you.
না না যাক ভালো করে পড়াশোনা for 2 judgments and my lord, I have argued the matter This is one of the judgment.
Bandyopadhyay, it was taken up a long time back. Is refresh.
No, this is blood. We have
Only
said
issue. It may come back to my-
we have said this is a maintainability point.
What was the issue?
Issue was that the regarding the promotion, appointment, recruitment.
Recruitment for the post. The affidavits have been exchanged.
Yes, everything.
Yes.
And Murad, we are suffering from an interim order. We have taken the point of maintainability. This is not maintainable. Murad. Now why the cooperative society lawyer made a very elaborate submission before the lordships on that day. That kindly similar
For the cooperative society.
that the very fair Mr. Sureka. Mr. Sureka.
Where is he?
Register of cooperative society.
You are appearing. You are appearing for the register.
Register is not a party. Register is not a party.
Who is the respondent number 6?
Added party added.
Respondent number 6.
Hey Rahul. Only 2024 Calcutta High Court notes. Page follow. 24 Calcutta High Court notes. And তুমি পড়ে
Yes,
আসো
register is the party.
মানে
That-
এসে
that-
বলো সব
That's what Mr. Sureka paid for being added.
All right.
But
Now
that is not a proper party.
she has been added
It
now.
should not be heard.
All right. Yes.
Yes. Murad, this is আরে জাজমেন্ট গুলো দিয়েছিল দাও ভাই সব ক্লিয়ার ফাইলে রেখে দাও 2024 Calcutta High Court notes equal to 2024 SCC yes অমর কুমার মল্লিক দাও জজ সাহেবকে দাও
You lost.
হ্যাঁ আচ্ছা বাবা দিচ্ছি 1 মিনিট
Lawyer never
2024
loses, Mr.
Huh?
Lawyer never loses.
no lawyer never this is Mr. Chatterjee used to say Arun Prakash Chatterjee.
Yes.
In fact, I am today going to rely a number of judgments in another court. They are the other side who are appearing. They argued in the other day and cited that judgment. No lawyer never loses. That is the whole. Well, kindly come to
Yes.
paragraph 42. Bombay judgment. Regarding the point raised on behalf of the respondent, Cooperative Society of Maintainability of the writ petition, it can be said that the said society, excepting serving its member, pursuant to the prevalent law and bylaw, has not been working for promotion and preservation of any public purpose. Admittedly, it is a society to provide for its members, and any action thereof would not influence, control, or govern the public. The argument advanced by the on behalf of the Cooperative Society by Mr. Mitro that the same is neither the state nor any instrumentality of the state, and that it does not render any public service, and the primary motives of its operation is only to earn returns and profits, appeared to be convincing in the light of the judgment relied on by the Learned Senior Council, which have been mentioned above. Accordingly, the traits of a state could not be attracted in case of the cooperative society respondent. The agreement entered into by the so of the society would be a contract executed between two private parties, that is the appellant and the respondent society. The dispute relating to which shall never be amenable to the jurisdiction of this court. The Honorable Supreme Court has held that even if the state enters into the field of ordinary contract, the relations would no longer to be governed by the constitutional provisions, but by the legally valid contract which determines rights and obligations of the parties inter se. In some other cases, it was determined by the Honorable Court that even in a case of a statutory entity, once the parties have accepted the conditions of contract by entering into it, they can only claim right conferred upon them by the said contract and are bound by the terms of the decisions of this court. Thus, being the provisions of law settled, and also the present cooperative society having been found not to have any tenet of being a state or instrumentality of state, it was not open for the appellant to approach this court of equity on the plea of infringement of any of his fundamental rights and or prejudice caused by any action of the cooperative society. In other words, the writ petition would not have been maintainable in this case against the respondent cooperative society. Over the above the points on merits, the preliminary point maintainability of the writ petition is also answered against the appellant. But here the question was that one of this cooperative housing cooperative society it was. And in a housing cooperative society, allotment was given to someone. He handed over it to his sister, and that was not without the sanction of the cooperative society. Therefore, that cancellation was that was challenged, and then this judgment is there. Another judgment, Miller. This is a now. This is a 3 judges bench judgment of the Bombay High Court. That is, Miller, the Maharashtra Law Journal 1993. Three judges went to Supreme Court.
Yes.
All the 3 judges. Come to paragraph 16. Come to paragraph 19. Miller, kindly come to paragraph 19. It is, however, submitted a cooperative bank. Paragraph 19. It is, however, submitted a cooperative bank, as in the present case, perform an important public function, and that itself is sufficient for coming to the conclusion that it is a state under Article 12. It is submitted before us that in a welfare state, the definition of government function has to be widened to include within its scope all functions which are of public importance. Hence, any organization which performs a public function must be considered as state under Article 12. In our view, this is too broad a proposition. We have to bear in mind the note of caution sounded by the Supreme Court in the case of Ajay Hasia and Tegraj Vasandi. Every organization which carries out a function which is of public importance does not necessarily become state under Article 12. Conferment of statehood depends upon various other factors also, such as the nexus of such organization with the state, the extent of state control, whether it is entirely financed by the state or private individuals. That's very important, Lord, here is coming. Whether the same function was originally carried out by department of the state and so on. There may be many functions of public importance which can be performed by private organization also. We have a large number of organizations doing important social work vital to the community. There are, for example, organizations which look after, educate and train handicapped persons, of the blind, provide them with jobs and rehabilitate them. There are private charitable organizations which may provide free or subsidized housing to the poor of free medical aid. They may be private organizations engaged in transport of goods and men. They perform which are undoubtedly of public importance, and they subserve a public need. But this does not necessarily make such organizations state under Article 12. Banking, here is a banking. Banking is undoubtedly function of a public importance. In fact, the nationalized banks do carry out this function under the control of the state. But that does not mean that banks which are not so controlled or banks which are set up by private organizations or cooperative societies become state under Article 12. In a welfare state, many activities which are often carried on by private organizations are undertaken by the state. In such cases, the Supreme Court has said that we must look at the overall position of the organization in the light of the other tests also, especially when the function of the organization is not such as can be carried out only by the state or is not connected with the government function. But these are the 2 judgments I wanted to cite. Therefore, this is maintainable point has to be decided first. And if it is not maintainable, then your lordship will dismiss the petition vacantly. And we are suffering from the interim order for long, Miller.
What was the interim order? Not to publish the result.
Not to publish the result. Although after passing of this interim order, the state has said not to publish the result, but because of the interim order which has been passed by your lordship, state has also passed that order. Therefore, the interim order is vacated. Whatever the state will do, that we will see to later. These are the 2 judgments.
Anything more?
No, nothing. I have said, in my affidavit, I have said that this is not a state, etc., etc. This is a legal point.
5%. Yes, Mr.
5% share is of the state government. That doesn't mean, the state.
There is no deep and pervasive control.
No deep and pervasive. If this is 51, I would have not argued this matter. Can I go to the tellers?
Yes, yes.
The aspect of cooperative societies. Nature of cooperative society comes later, my lord. Whether it's the housing, it is banking. Taste is not that share is held by the private bodies or public bodies. This is not the case so far, as laid down by our High Court. The test is whether there is a violation of rules and the provisions. If the cooperative society violates the rules and provisions of the Act, it is
Federal Bank.
well, the first judgment of our High Court, delivered by the Honorable Mr. Justice Bonendonath Roy, 1999, 2 CHF, page 284, 8 and 9. That's Arjad Ali Gaji. Well, I will cite this reports of my submissions. This view has been subsequently affirmed by the Supreme Court in Ahmedabad Cooperative Societies. So, test is there is a violation of law or not. Now, my lord, I take your losses, what we have come up for. Now, your losses kindly consider page 18 of the writ petition.
Yes.
But we have questioned this validity and legality of this notice vis-a-vis the provisions of law under the Cooperative
Page
Society.
18.
Page 18, if I'm not wrong. My lord, the pagination probably will be right, my lord, of the writ petition.
Yes.
My lord, Ghatal Cooperative Agricultural and Rural Development Bank Limited will appoint 18 youths on contract basis. Eligibility, minimum qualification Madhyamik pass, age limit 18 years to 40 years, as on 1st October 2025. Mode of application physical only. Applicant himself has to submit the application along with other documents in the drop box of Ghatal Cooperative Agricultural and Rural Development Bank Limited, such and such, of 14th November 2005. Then next year losses will find issue of admit card for competitive examination, all that. Similar, we didn't apply for, why I will not submit that to lawsuits. We question this on the anvil of the provisions of law. Your losses will find that
Cooperative Societies Act.
Cooperative Societies Act and rules. If your losses kindly take up the rules, your losses for once.
Yes.
Yes. Capital A. But may I just one thing, just before taking your losses to rule, your losses kindly take up the affidavits submitted by the cooperative society 2, 3, and 4. Let me complete the facts, your losses, so that we can proceed.
In opposition by
2, 3, and 4.
two, 3, and 4. Yes.
Now kindly take up your losses, page 4.
Yes.
Paragraph 7. I say on October 18, 2025, an advertisement was published in Sambad Proceedings towards recruitment of 18 people on contract basis, where it was clearly mentioned that any interested applicants are required to submit such an application in terms of the paper publication physically at the office of the respondent number 2 within a particular time and date upon verifying the other particulars which were available at the office of the respondent number 2. Next paragraph. I further say, accordingly, a notification by reference number such and such was published informing about the monthly remuneration of the selected candidates who are keen to join the respondent number 2 as its employee on contractual basis or were made aware of the same. The same was affixed in the bulletin board at the office of the respondent number 2, and the candidates applying for the same were duly notified therein. Photocopy of the said notification is annexed here 2. Now kindly take up that notification on the same. But we had taken also in the writ petition that there was no such scale of pay or remuneration mentioned in the advertisement. Then this comes up before your losses by way of affidavit. On the same day. It's very easy, my lord. They have said this has hung up in the notice. Now your losses, page 12 of the affidavit. But the resolution of the cooperative society, vivido, miscellaneous. Well, this is not even the main agenda. মাননীয় সভাপতি মহাশয় বললেন ব্যাংকে বিগত 2012 সালের পর থেকে কোনো কর্মচারী নিয়োগ হয়নি। দীর্ঘদিনের অভিজ্ঞতা সম্পন্ন কর্মচারীগণ পর্যায়ক্রমে অবসর গ্রহণ করে, যে কারণে আমাদের অতি সত্বর বেশ কিছু কর্মচারী নিয়োগ করা বাঞ্ছনীয়। তিনি বলেন এ বিষয়ে পরিচালক মণ্ডলী 21/5/2025 তারিখে একটি সাব কমিটি গঠন করেছে। সবাই বিস্তারিত আলোচনা আনতে পরিচালক মণ্ডলী 21/5/2000 তারিখের সিদ্ধান্ত অনুযায়ী নির্ধারিত সাব কমিটিকে উক্ত নিয়োগ প্রক্রিয়া পরিচালনা করার কার্য প্রদান করা হয়েছে। এ বিষয়ে ব্যবস্থা গ্রহণের জন্য অনুরোধ করা হলো। সিদ্ধান্ত গৃহীত অতি সত্বর ব্যক্তির নিয়োগ করা হোক, যা অধ্যক্ষার সভায় সর্বসম্মতিক্রমে অনুমোদিত হলো। The next page your lordships will find কর্মী নিয়োগ সংক্রান্ত বিষয়ে আলোচনা ও সিদ্ধান্ত। ব্যাংকের সভাপতি মহাশয় বলেন ব্যাংক দীর্ঘদিন ধরে কোনো কর্মচারী নিয়োগ না হওয়ার কারণে ও সিনিয়র কর্মচারীগণ পরপর অবসর গ্রহণের কারণে ব্যাংকের দৈনন্দিন ক্রিয়াকলাপ যথেষ্ট অসুবিধা হচ্ছে, যে কারণে আমাদের খুব শীঘ্র বেশি কিছু লোক প্রয়োজন। এক্ষেত্রে অতি প্রস্তাব রাখেন একটি কমিটি করে সিদ্ধান্ত গ্রহণ করলে ভালো হয়। নিম্নলিখিত কমিটির সুপারিশ করবে। Then your losses will find that another document your losses will find sanction strength grade 1A 2 grade 2A 3 all that. Officers post such and such other than officers post all that. Malak, I don't think this is the vacancy or that, but this is they have annexed to the petition. What does it carry meaning? Your losses I do not know. All that I'm trying to make.
It's a vacancy position.
Vacancy position. Malak, contractual advertisement doesn't say malak the vacant malak the nature of the post. Kindly have a look at your losses.
Yes, yes.
Only madhyamik pass. I will take your losses to that. Now, my first point, your losses on facts. If there is a vacancy from 2012 and you have the sanction posts, what prevented you from processing on a regular basis without due and fair advertisement? But I will go to your losses autonomy. Autonomy doesn't mean autocracy. Therefore, they could have done it. So, this is an appointment process. It's a backdoor appointment process. To contractual process, I need it. Therefore, this should be. For more than a decade, according to you, there are vacancies. Gradually, these increased because you didn't recruit. Because the regular recruitment process prevent your hands from corruption, which you do not want. And that's why this backdoor process has been necessary. Now, then your losses will find factually. Then I will make kindly take up the state affidavit. State affidavit, respondent number 1.
Yes.
Page 7. A complaint was lodged by one Gurupada Ghosh before the Honorable Minister in charge cooperation against a number of unlawful contractual appointments, including the son of the chairman of your bank. You also might remember on the day of the motion, they said no. They made it. That's the whole intention of this sort of process. Now I am directed to send instructions so as to dismiss the contractual appointment of Somen Bauri, son of the chairman of the bank. Specific, we made a specific submission in regard to this in the writ petition also, if I'm not wrong. Stop the recruitment process of 18 number of contractual employees until further order from the same. An action taken report in this regard should reach the same within 7 days from the communication of this letter. Then your losses, kindly see the next page. In reference to the above, this is to undersign is to state, after receiving both of your orders, I immediately provided those to the chairman of the Ghatal, this Cooperative Agricultural and Rural Development Bank, to abide by the orders and submit a report of our onward submission. However, the chairman of the has submitted the required action taken report on 13th December 2026. This is for your kind information and necessary action, please. Then next page, your losses. In response to the instructions of the additional register of cooperative societies, Soren Bari is not in our payroll. He worked till December 2025 only. Can you listen? So he was appointed by the son of the chairman. Now, according to order dated such and such of the Honorable, examination has been held on 1st February 2026, but result has been withheld. So, my lord, I do not know whether state is appearing today or not, but their presence, my lord, because there is a constitutional body, Panchayat. Their presence is necessary, my lord, for determination of the issue. Now, my lord, when we move this petition, my lord, kindly, my lord, take up the rules. That's Lord, kindly come, we will also consider 104 capital A. Lord, this gives the power of to the board of the cooperative society to create posts of different categories. Lord, admittedly, there are sanctioned vacancies according. Now, 105 procedure for direct recruitment of state by cooperative societies. Subject to the provisions of Rule 104A, all cooperative societies shall notify their vacancies other than those required to be reported to the Cooperative Service Commission. Malad, here, Malad, as I find your losses from all that vacancies, those are above Group 3. Therefore, report should be given to the Malad for recruitment to the school service, Malad, Cooperative Service Commission. Through publication of advertisement at least in one national daily newspaper and to the local employment exchange and such and such. For selecting the candidates, selection committee for selection of staff other than Group 3 may hold such test and interview or vivacity test as it may consider expedient. In cases of the local employment exchange or the director national employment will not be in a position to furnish suitable names within 2 months from the date of the notification of the vacancies, the concerned cooperative societies may start recruitment process of application received on the basis of the advertisement. But kindly take note of this, because I will rely upon this, that autonomy does not exclude these provisions.
Mr. Sandal, only for once. This relates to creation of posts and appointment to those sanctioned posts.
Exactly.
Whether these provisions will apply for contractual appointments also.
I tell your losses, contractual employment also. Now, even if your losses go by contractual appointment, what are the nature of the post? Now, kindly have a look at your losses.
Because these provisions are for appointment to those. First is creation of post 104A. Next is appointment to those posts. So these are the procedures which have been laid down. But this is not an appointment as per section 100 or rule 105.
Malad, I tell your losses. Now, if your losses kindly consider the your losses kindly consider, Malad, appendix to rule 106.
Yes.
Now, Malad, there are 4 category of posts. Group
Mr.
A.
Sunal, you do not fall within cooperative credit structure entity.
But I'm coming to that. I will. What my learned friend has sent me submission.
I'm asking you, do you fall within
according to the definition, I come.
If you come, 106 do not apply.
No, that's I will deal with that submissions. I will deal with that submissions. Malad, it's not a question of Malad, this applies. Whatever 134 says, overriding effect. That doesn't mean exclusion of the provisions. Doesn't mean exclusion of Article 14. Doesn't give the autocracy to do whatever they like.
No, that is one thing, but 106 may not apply. And the appendix to chapter
my submission will be, this will be applicable.
Even in respect of cooperative credit structure entity.
Exactly, your lordship. I tell you why. Because of the nature of the advertisement.
Only one thing that I record that you are not disputing that it's a cooperative credit structure entity.
But I do not dispute that.
Those on facts, you cannot dispute that.
No.
Yes.
Now your losses kindly will look at Malad 106 appendix chapter 5.
Yes.
4 categories of post. Malad, they have given the vacancies. Malad chart shown. Now Malad group C clerical and operative. Group D subordinate staff. Now kindly see your losses group C or B.
Qualification.
Qualifications. Madhyamik pass certificate with knowledge in computer science. So Malad, they have said only Madhyamik pass. The nature of post not disclosed. Malad, whether they are recruiting group D or group C, how could I apply your losses? That's the basic requirements. It doesn't, Malad, go with the autonomy. You have the autonomy. But it doesn't mean that you will not follow the basic norms. Just fair principle, transparency and fair principles. Here your losses, they have to follow this. Autonomy doesn't exclude these provisions. It includes these. Kindly will look at your losses, the term. Give losses kindly. Section 134 capital A of the Act. Malad 134C, subsection 2.
134C.
C. Then I will take your losses, the 134.
Yes.
Subsection 2. A cooperative credit structure entity shall have autonomy in all financial and internal administrative manner, including the following areas. What? Personal policy, staffing, recruitment, posting, and compensation to staff. Now, Malad, therefore, what is this? They can recruit on their own. That doesn't mean, Malad, that whatever they can like, even in case of Malad contractual employees, they will not say, because Malad, these are the qualifications, these are the nature of post. Contractual appointment can be made to the post also. You must disclose it. What are the nature of post? Kindly see your losses. Page 134.
134A.
134 capital A. Overriding effect. That's overriding effect, notwithstanding anything contrary or inconsistent contained in this act or rules framed thereunder or bylaws of any registered society or orders issued thereunder. These provisions of this chapter shall have overriding effect. Malad, overriding effect doesn't exclude those provisions. These are the basic provisions to maintain transparency and fair play. And notwithstanding anything contrary, Malad, it is not contrary to the autonomy. Those provisions are not contrary to their autonomy. Suppose your lawsuits, had there been a provision
Case of conflict.
Exactly. Had there been any specific provision under subsection 2 that they can do this way, which contrary to the main provision, then Malad, it could have an override. So Malad, this is the violation of the provisions of law. And Malad, as I just say, Malad, make a repetition. Malad, they say from 2012 the vacancies are lying. Gradually, Malad, this is increasing. What prevented them to start a regular recruitment process? Except through this backdoor process. Here your losses, kindly consider this judgment of our High Court. Adjust your losses. 1990 volume 2 CHN. 1990 volume 2 CHN, page 284. paragraph, well, I give your lordships, 8 and 9. I just your lordships give the paragraph.
The 99 is the 90 question.
8,
1990.
1990, volume 2, CHN, page 8, 284, paragraph 8 and 9. Plus Arjad Ali Gaji. Well, this has been followed. That's why I submitted for the test is whether there is a violation of statutory provisions of law or not. And Article 14. Test is not, my lordships, that the entities have the private shares and the government shares of 5%. That's not the test here. Well, kindly see, after considering the paragraph 8, after considering the respective contentions of the learned counsel appearing for the parties, giving our anxious thought to the facts and circumstances of the case, it appears to us that having accepted the prayer of the writ petition, the governing body had already imposed a penalty of penalty and reversion. Fine, or it should be fine. Therefore, there was no occasion to take further steps to cause inquiry on an admitted position and to pass an order of dismissal. In any event, such inquiry having been made expert and behind the back of Sigaji and punishment having been passed expert without giving Sigaji an opportunity of being heard, there has been violation of the basic principles of natural justice. In such circumstances, there is hardly any impediment in quashing the impugned order of dismissal. But the difficulty lies in deciding the question about mentability of the writ petition for issuing a writ or direction against the impugned order of dismissal. A cooperative society is formed by the private initiations or its members, and despite the anxiety of the state legislature to ensure functioning of a cooperative society in a deserted manner and making various provisions in the Cooperative Society Acts and rules and thereunder to exercise control in the functioning of the cooperative society by the Register of Cooperative Societies and other officers of the state government, a cooperative society is not a statutory body or an instrumentality of the state. The decisions made by various high courts and also Supreme Court on the questions referred to above are quite specific. Ordinarily, a writ does not lie against a private body, but the position will be entirely different if such private body is vested with statutory duties and functions. For inaction relating to statutory duties or improper action contrary to the statutory provisions, such private body becomes amenable to the jurisdiction. In this question, reference may be made to a full bench judgment of such as Andhra Pradesh that her body is vested with the statutory powers affecting right of citizens. Then, my lord, certain discussions are discussed. Then your lordship, paragraph 9 is material. It appears to us that in the instant case, conditions of service of Sikh Gaji as an employee of the society have not been controlled by terms of contract. Well, that schedule 106 I placed your lordships. If your lordships go through further, your lordships will find the certain terms. How the recruitment, how to be dealt with, how suspension, how disciplinary procedures. But in the absence of terms of contract for service, service conditions have been left to be controlled by the said rule 108, which is undoubtedly a statutory rule. The society therefore has an obligation to comply with the statutory rule in the matter of discipline relating to employment of Sikhaji. Where a duty follows from the statutory rule in the matter of employment, although such employment may be at the inception a product of private contract between the parties. In the matter of regulation of the condition of service of such employment, a duty or a public nature comes into operation. Accordingly, for breach of such obligation, under statutory rules, a writ petition for appropriate writs and directions are made. So therefore, the court intervened and the entire order of punishment was passed. Paragraph 10 onwards, your losses will find. Yes. So therefore, test is this, my lord. Now.
Yes, done. Not sufficient work on this. The basic question with that Article 1416 in case of the employment, and the public funds are anyway involved. You have to follow that. Transparency is the basic requirement of constitutional democracy. Therefore, Cooperative Act empowers you to do something. Giving overriding effect that you follow these rules, nobody will interfere. That's the overriding effect.
And they can recruit also as a.
And my lord was kind enough to direct only that very well. He produced in which category you have taken the examination. Because now we find the contractual appointment even case of the assistant professors are done. In the cooperative, they have not been, but maybe because grade one officer, maybe without grade two officer.
Of doctors also.
Contractual appointment, they have a contractual is a very vague term. Unless you specify the designation. I don't know whether I will be able to apply.
And without computer knowledge.
And by that, you are very technically excluding a large section of people who would have been better than the others who we have chosen. But this is, again, I say with due caution, the gateway of doing corruption. That has to be stopped.
How much time will it take?
So this is the submissions.
And we'll place our reply, Your Lordship. We have to reply to their.
Your reply.
We'll.
Wait, I'm coming after 5 minutes. Reply.
Mentality available.
Right, that, you want to cite any other decisions?
No.
Origins have.
She will come back. I included 5 minutes.
To the reply to what your lordship, the petitioners have made their submissions with regard to maintainability.
One thing I tell you, Lordship, register is not a proper party.
No, I am a proper party. I have been added as a
Not
party.
even your lordship.
Don't fear me. I am going to place the law.
Where-
No, I am placing the
as a
law.
party,
I am the supervisory authority of all the cooperative societies. I am the most interested party. Let me make my submissions, your lordship.
Interested party,
Ah.
register must be.
Interested to protect the functioning of all the cooperative societies and to stop frivolous litigations. So, your lordship, in paragraph 1, what we had pointed out,
Paragraph 1 of
their writ petition, what we had pointed out in our maintainability submissions, that they have to first satisfy whether this kind of cooperative societies falls under the definition of state in order to maintain this writ petition.
No, Mr. Sanlal's submission is other way around. His submission is that even if it does not fall,
It means he has considered that this is not state.
yes, but
He has considered.
if he has to exercise certain powers under the statute, then it comes.
Everyone is aware of
those
this, your
cases
lordship.
of private banks.
Your lordship, everyone is
May
aware
not
of.
be Article 12, but with regard to certain functions, certain statutory,
If that statutory functions are applicable
Well,
upon us, if
yes.
it is to be followed by us.
yes.
Now
If
the
there is
first
violation with regard to that, then for that limited purpose, writ is also
that
maintained.
submission I had also made at the time of taking the point of maintainability,
That is the
that there
submission
are two issues. One is whether it is state or not. Now, when they have considered that it does not fall under the definition of state, now I have the second hurdle to cross. That is whether any statutory provisions have been violated or not. According to them, they have relied upon 104A of the rules.
Yes. And 4A.
Their best case is that 104A has been violated. Your lordship, kindly sees rule 104A, sub rule 3.
Yes.
Nothing contained in this rule shall apply to a cooperative credit structure entity which shall have the freedom to make its own policy on recruitment, posting, and compensations to staff. So, in their submissions, they had also accepted that this kind of a cooperative society falls under the definition of cooperative credit structure entity.
Yes.
So, if this rule is not applicable in our case, in the case of the bank rather,
Yes.
the question of violation possibly it cannot arise. The question of any statutory rules being violated by these kind of cooperative societies is not maintainable. A writ against these kind of statutory violation which does not bind them to do something. And the reason for giving them autonomy was that there was a sea change in the 1983 Act. Thereafter, this 2006 Act came, which was implemented, given effect from 2011. Now, the Arjad Ali Ghazi judgment, which they have referred to place that if there is statutory violation, then the writ will be applicable. This judgment was passed in the year 1990. At that point of time, 1983 Act
cooperative credit structure
was not existing. Secondly, the writ petition was directed against an order of the Secretary, Dakshin Barasat Service Cooperative Society. So this cooperative society, even then, does not fall under these kind of cooperative societies who are engaged in credit lending and credit business. This is a service cooperative credit society. Even today, 134C does not exclude all kinds of cooperative societies. Even this service cooperative society today is not excluded from the ambit of this 2006 Act and the Cooperative Service Commission. So this judgment may not be of any help to them to support their case that the writ is maintainable. Now the point of other statutory violations they have not pointed out. If they have pointed out, your lordship,
say to this 134A.
134A. This gives an overriding effect. There is overriding effect. Why, your lordship, why this act has been, why these provisions have been incorporated? It has been incorporated by an amendment. Why so? kindly considers the 1983 Act, if your lordship has it. 1983. Your lordship, if your lordship has the 2006 Act, if your lordship kindly sees there is a chart comparing what are the provisions which existed in 2006, 1983, or which are there in 2006 Act, which was not there in 1983. The first few pages of the Act has a chart, comparison chart. Your lordship, may I hand over my book for once? Your lordship,
Yes,
kindly see section 2 and 3.
yes.
It is in the 2006 Act, but it was not there in 1983. Now, your lordship, what is there in 2006 Act? Your lordship, what is there in section 2 and 3?
The 2006 Act.
In the 2006 Act, which was missing in the 1983 Act, which was considered in the Arjad Ali Ghazi case.
Yes.
And why this amendment has come in, this 134 and the chapter 13A. It shall be the policy of the state to promote cooperative societies, which are instruments of equity, social justice, and economic development in fulfillment of the directive principles of the state policy as enshrined in the Constitution of India, save and otherwise expressly provided in this Act. The state shall not interfere in the management and operation of the cooperative societies, and shall recognize cooperative societies as democratic institutions owned, managed, controlled by members for their economic and social betterment, operating their business based on mutual aid and cooperative principles. Same are the principles which have been enumerated in section 3. Considering these two provisions which were absent in the 1983 Act, this amendment has come in, this chapter 13A. So prior to that, when 2006 Act was enacted, there was a provision at section 94, Cooperative Service Commission.
94 of the
2006 Act.
Yes.
Because this amendment has come in 2011.
Yes. Service Commission.
Service Commission kindly sees the state government shall constitute a cooperative service commission, hereinafter referred to in the section as commissions, and shall appoint following 3 persons as the members of the commission: 1 person who held the post of so and so, 2 persons from so and so. The chairman and the other members of the commission shall hold office for a term so and so. Kindly comes to subsection 5. The commission shall select persons for appointment to such posts other than posts of Group D category and posts to be filled up by promotion in the cooperative societies mentioned in 5th schedule of this Act, and in doing so shall follow the procedure and guidelines as may be prescribed, provided that any appointment made by a cooperative society of the 5th schedule in this Act in violation of the clause shall be void. So there was a restriction. It was there till 2011, for which these kind of cooperative societies who deal with credit lending, who have direct access, much more direct access to the public, to uplift their working, to give them autonomy, to build confidence among the people to invest, to keep a good relationship with the cooperative societies. Because these are not very big cooperative societies, these are small cooperative societies in which the local people have faith. To repose faith, they have to work according to their needs. The state government cannot impose restrictions. So this autonomy was given. This 134A, chapter 13A was incorporated.
Yes.
And if any provisions of the Act which says that you have to do something in a particular manner, and if this overriding effect is there, which gives me autonomy, chapter 13A, 134C to D.
134C to
D.
Yes.
When we do not have any quarrel with the definition of the cooperative structure entity, then these provisions are applicable to this case. Then 10(2)D gives this kind of a bank A cooperative credit structure entity shall have autonomy in all financial and internal administrative matters, including the following areas. The question of quarrel, the question of there being any inconsistency is not there. This is to me given, to the bank given.
So according to you, this 134 CT, C2D will have an overriding effect over 94.
And that is the reason for which all the rules which were there existing in the 2011 rules have been the provisions of this autonomy has been inserted wide amendment dated to 1st of February 2013.
Yes.
Kindly seize the rules 104 again for once, Your Lordship.
Yes.
4A, sub-rule 1
Yes.
was there, sub-rule 2 was there, then sub-rule 3 has come in. And if you see the footnote, it has been inserted in the year 2013.
Yes.
This was to supplement or to give strength to the provisions of chapter 13A. If we today say that this insertion has no value, the autonomy given to these kind of cooperative societies under chapter 13A will become redundant. If they have to follow all these policies, all these provisions, then this chapter becomes redundant. So this 104A is not there. Then the subsequent provisions are not there. In fact, the method and recruitment and conditions of service of the officers and employees of the cooperative societies, which is there and still applicable to other cooperative societies as per Rule 106, has been excluded.
Yes.
I have to work, the cooperative banks have to work as per their own capacity. It may not be possible for a cooperative bank who may be running in losses, who may not have such kind of capital exposure, who may not have that kind of transaction in every year, that he has to hire a CA on a regular basis, or a person of a bachelor's degree when his work can be done with a madhyamik pass person. So these are the autonomies which have been given, because if the bank hires someone of a higher qualification, the pay chart cannot be of a lower category. So these are the autonomies given in order to sustain these kind of cooperative credit structure entities, and these cooperative credit entities also include the PACs at the village level, who provide subsidies and who distribute rather subsidized fertilizers to the local farmers and all. Thirdly, Your Lordship, we had also placed the judgment of the Honorable Division Bench. That was the Subodh Mandal, which have recognized that these kind of cooperative societies, Chapter 13A is applicable. (2025) SCC online, Calcutta, 2666.
Subodh Kumar Mondal. Yes.
Subodh Kumar.
This you had cited.
Yeah, Lordship, I had cited.
Yes.
Kindly seize the paragraph 13 and 14. And issue of, may I place the paragraphs?
Yes.
Issue of maintainability of the writ petition requires consideration. It is admitted that the concerned cooperative society falls under the parameters of 13A, which they have also admitted in this case, of the West Bengal Cooperative Societies Act 2006. By virtue of the concerned cooperative society coming within the purview of Chapter 13A of the Act of 2006, the regulations governing the service of an employee of a cooperative society was not applied to a cooperative society coming within the purview of such chapter. The decision of the Calcutta High Court cited on behalf of the appellant in support of the contention that the service conditions, Your Lordship, this kindly notes, in support of the decisions of the Calcutta High Court cited. Your Lordship, if Your Lordship comes to page 2, paragraph 9 of this judgment, para 9, page 2, para 9 of this judgment.
Yes.
Kindly sees 6th line, Your Lordship, or the 5th line starting at the right hand side, 1990 SCC online, Calcutta 220, Arjad Ali Gaji versus State of West Bengal.
Yes, this was
Considered by the Honorable Division Bench.
yes.
Cited on behalf of the appellant in support of the contentions that the service conditions of the appellant are governed by statutory provisions and therefore writ is maintainable, cannot be accepted in view of the fact that the concerned society comes within the ambit of Chapter 13A of the Act of 2006. Moreover, the appellant before us is an employee so-and-so superannuated for service and so-and-so. So these things have been decided. They have not been able to distinguish the same. Thereafter, this judgment continued, and there are observations and decision at para 24, which also relied upon 2 other judgments of the Honorable Apex Court.
Yes.
The decision cited on behalf of the respondent reported in 2006-11 SCC SS Rana says whether the respondent is stayed within the Article 12 of the Constitution of India, which they have accepted, it is not. The appellant is to show that the state has deep and pervasive control over the society, but the appellant does not satisfy the test laid down in Pradeep Kumar Biswas. So they have failed to show that it is state. They have failed to show that there has been a statutory violation because there is no particular statute controlling the matter of recruitment. And if there is any other instances of corruption or any malpractice, this is for the registrar to consider. They cannot usurp our powers and come to the court and bound us at their whims and fancies to come and take steps. This is my submission on the point of interpretation.
Just to add one thing, adopting everything Mr. Surekha has submitted, the question remains to what extent they can intervene when they have chosen not to participate. That is one issue perhaps which has not been addressed. They have chosen not to participate. That point is also there in my maintainability application. They do not even have the locus. They say they were unaware, they say the terms and conditions were not favorable for them, so that they could not participate. Now, there are 240 people who had participated. It's not a question that the question of backdoor appointment would only come if there are 20 or 30 people. There are 240 people who have participated. There was an examination which was held in everybody's presence. There's no dispute to that fact. So, the question to what extent a private individual, without even participating in a recruitment process, can challenge when there is an autonomy. And one thing I wanted to show, my learned friend has shown, because my learned senior friend has cited the 1990 Arshad Ali judgment. It has been considered by the division bench of our honorable court. So that no more remains a good law post amendment. That is precisely our case, my lord.
You have cited that decision that if he has not participated, he has no locus. I think you.
My lord, perhaps I had cited on the earlier occasion. First judgment 2011, my lord. 2011 Supreme Court. That is in the interim stage, my lord. I had cited 731.
2006-11.
2006, volume 11, my lord.
Having participated, I cannot question. That's the law.
Which paragraph of this judgment?
My lord, I have perhaps relied on para 43, 44 and just check up once. Yes, para 43, 44. This is not a regular appointment. This is a temporary appointment. The basis of the appointment is due to the exigencies in the organization.
43, 44 is co-warrantor.
Yes, and now, my lord, what it deals is, my lord, in the nature of appointment, my lord. What is there, your lordship will find the terms of.
Where is that if he has not participated in that, he has no locus benefit.
No, just give me a moment, my lord, I'll just check up on it. Oh, my lord, I'm sorry, my lord. This is 2023 Madras, my lord, which I have cited, my lord, with regard to that point. It kindly comes to. Yes, my lord, I'm sorry, I'm really sorry. my lord.
29.
29 onwards, that is, my lord, the issue in question, my lord, and then, my lord, the observation is at para 46. No, there are other paragraphs also which I have relied, my lord. But, my lord, the 46 is the observation. There are other paragraphs also which I have relied. As seen above, it is clear that the petitioner is not an aggrieved person but a stranger to the selection process for appointments under such and such by the sixth respondent corporation pursuant to the recruitment notification issued by them. Therefore, the petitioner does not have the locus standi to maintain the writ petition, and only persons who have applied for the subject post based on the recruitment notification issued by the sixth respondent corporation who were unsuccessful have, if at all, any legal right to file a writ petition challenging the selection process. For the foregoing reasons, the court is of the considered view that the writ petition filed by the petitioner is not maintainable on the ground that the petitioner is a stranger and not eligible to apply for the post of junior assistant due to the age, and therefore, so this is on the issue that, but the ratio is, well, they have purposely chosen not to participate. And only after, well, this, just a day prior to the examination was to be held, well, they came up with this urgent writ petition to stall the entire process. So, my lord, my deepest submission, my lord, with greatest respect, my lord, a stranger should not be allowed, my lord, to interfere in the autonomy of a private cooperative, my lord. An admitted position, it's 5% shareholding of the state. Well, these are the my submissions, my lord.
Yellow. Two side.
Mr. Sannal, if you succeed on the maintainability, so these are those are your submissions on merits only.
Yes, well, he has
So
made
your,
submissions on
I
merit.
think, is it only maintainability or the main writ petition?
Your Lordship kindly
Because
decides the maintainability.
further submission you have to make on the merits.
Your Lordship kindly decides maintainability first because this is required to be.
Maintainability will be decided. I'm asking if the maintainability, Mr. Sannal succeeds on the maintainability. If he does not succeed on the maintainability, everything goes. I'm asking him, if you
So far I am concerned, I have submitted on merit inclusive of payment.
because your submission is that the entire selection process or the entire initiation of the selection process, that's bad in view of
My
those.
humble submission, there is no inconsistency between the two provisions, overriding provisions.
No,
Does
that is that, no, on merits.
Autonomy does not mean
on-
autocracy.
Yes, yes. On merits, your submission is that in such a manner this selection process could not have been conducted. First is contractual appointment is in violation of those statutes. Second is, even if they have a power to make contractual appointment, it could not have been on such vague notice.
Contractual appointment can be made against the post also.
So could
With
not
a
have been,
lump sum amount,
so could not have been.
qualification not followed,
Yes, so
computer mask, no.
yes, so could not have been made on that vague notice. So what remains? So I can
Dispose of
Yes,
it.
your lordship can dispose of, because he has made his submission on merits on the very first day. His submission is on the issue of violation of the statute,
I'm also
nothing more,
recording that
nothing
you
less.
have also made your submission on
Yes,
merits
my lord, we
also.
have addressed, yes, we have addressed.
And because on merits,
We
your
have disclosed the
submission-
documents, my lord, in the
yes,
affidavit.
you have disclosed, and your submission on merits is that in view of those rules permit you to do, and
Autonomy.
accordingly you have done. So that's your
We have
submission on
exercised
merits.
autonomy and not autocracy, according to Mr. Sannal.
On the mentality. Exercise. Yes. Please tell Mr. Bandyopadhyay, because he said he argued only on the maintainability. If he has something, please tell it.
Lord, I don't know, Lord.
Ask him, if he can come before 1, please inform Mr. Sannal then. Only for 1-2 minutes. If he wants to make submissions on merits, then I will close it on the maintainability only. Otherwise,
I don't think it is required, because the scope is very limited. My lord, if I succeed on the maintainability, I succeed on the merits as well.
Mr. Bandyopadhyay, because he was under the impression that it's only on
Because, my
maintainability.
lord, your lordship
Because
knows, if I succeed on the maintainability, I succeed on merits. And if I do not succeed on the maintainability, then the issue of the violation of the provisions would come. It is
Yes.
as simple as that, my lord.
Yes.
It has to go either way. It has to, if I succeed,
yes, if Mr. Sannal succeeds on merits, you have nothing more to submit.
nothing more to submit. Because then
Inquire from
it's
Mr.
only a question
Bandyopadhyay.
of applicability of the provisions.
Yes.
Whether it's applicable or not. That's the law. my lord.
Yes, call the next matter. Yes.
This matter was mentioned yesterday, my lord, under compelling urgency.
Yes, what is the urgency?
The urgency is that the respondent authority has issued a notice thereby directing me to vacate the land or he will dispossess me from the same, my lord. My lord, kindly takes up the notice, my lord, once. If I may place, my lord, whereas it has been noticed that the land situated at Vidyasagar colony under such and such is a private plot belonging to Shanti Devi Jaiswal as per government record. And whereas the Honorable High Court at Calcutta has directed upon the state to remove the encroachers from the land of petitioners and deliver back to the to peaceful possession to the writ petitioners. And whereas several opportunities have been given to facilitate rehabilitation after issuance of eviction notices by the BDO Bali Jagacha with you on dated such and such regarding rehabilitation program and land rehabilitation was identified and finalized at such and several arrangements has been made for suitable rehabilitation. And whereas on such and such another eviction initiative was undertaken through a display of general eviction notice on permanent notice board and by continuous public announcement directing all occupants to vacate the land situated at Vidyasagar colony under such and such. Now therefore you are hereby directed to vacate the occupied land along with all the belongings from the said premises within 7 days from the date of the receipt of this notice. My lord, this is the notice that was served on 19th May, my lord. My lord, now my lord kindly takes up, my lord, the order on which, relying upon which this notice was issued, my lord. It is at page number 29 of the brief, my lord. My lord, the first order, my lord. This writ petition was preferred by the predecessor interest of the person who owned the plot of land, whereby, my lord, by a order dated 7/3/2014, if my lord takes up page number 54, the ordering portion, my lord.
What was the challenge in the writ petition?
My lord, the challenge in the writ petition was, if my lord takes up page number 29, the page number 29 says, the erstwhile writ petition since decease has moved this writ application praying for relief against state respondents who are instrumental and responsible for dispossessing the petitioner, which is the the person owning the land, of which she is sole and absolute owner. Mr. Mukherjee, learned counsel appearing for the writ petitioner, submits that the erstwhile owner purchased such and such land within the district of Howrah from such and such person. Mr. Mukherjee submits that above plot was hypothecated to Central Bank of India as collateral security as against the loan given to MS Steel Profile Processing Industries. It was submitted that loan was sanctioned in connection with a project to be started in the said land. Mr. Mukherjee further submits that during recent settlement operation, the erstwhile petitioner, since deceased, applied before the appropriate authority for mutation of her name as owner and possessor of the aforesaid plot. On her application dated 29 January 1996, the office of BLLRO Bali Jagacha duly mutated the name of the petitioner as a recorded owner. The respondent authorities, particularly the state authorities, have accepted rent paid by the petitioner and issued rent receipts in her name, which are disclosed in this writ petition. It was pointed out by Mr. Mukherjee that the bank authorities subsequently issued a notice under Section 13(2) of the SURFACE Act, asking the company to pay the required amount within a period of 60 days from the date of issue of the notice, failing which the bank shall take over possession of the land as secured assets. Mr. Mukherjee submits that a godown was constructed on the plot of land for purpose of company and there was a room for posting of guards. During May 2003, the son of erstwhile petitioner, the present petitioner, went to
What is the dispute? Please don't read the entire order.
lord,
I'm asking what is the dispute?
the dispute is, my lord, that, my lord, if my lord comes to page number 13, my prayers, my lord, there was an order by this honorable court to rehabilitate the petitioners, a writ in nature of mandamus directing the respondents, thereby men and agents want to immediately provide proper rehabilitation to the petitioners, including land, housing, and necessary amenities. My lord, this prayer was directed, my lord, by this honorable court in the order that I was placing before, my lord, in page number 54, my lord.
Yes.
Last portion, my lord. Accordingly, this writ, if my lord takes up page number 54 once, accordingly, this writ petition is allowed with a direction upon the respondent authorities to remove the encroachers from the said land of the petitioners and deliver back the peaceful possession to the writ petitioner within 6 months from the date of communication of this order, and to find out a suitable place and or plot of land belonging to the central state government or any of its organs to rehabilitate the occupants of the writ petitioner's property. The cost of such rehabilitation is to be borne by the state authorities, including the Zila Parishad and Panchayat Samiti. My lord, I say, my lord, that this direction of this honorable court was not complied by the respondent authorities, and now, my lord,
Contempt.
my lord, thereafter, my lord,
File a contempt.
my
for
lord,
that.
we were
Nothing.
my
You
my-
did not
my-
obtain an interim order from 2020.
my lord, kindly seize the last order, my lord.
Since-
Kindly seize the last order of this court, my lord,
Yes,
in
yes.
this writ petition, my lord.
Yes.
Kindly seize, my lord. The last order passed by Justice Parthasarathi Sen, my lord.
Yes.
And my lord, this is pointed out, my lord. We were not parties to this writ petition, my lord. My lord, kindly seize the last order, my lord. It is a direction upon the respondent authorities to rehabilitate the petitioners and then remove the encroachment, my lord. It is noted in the order, my lord. This order, which I was placing, my lord, it was challenged before the division bench, my lord.
Show me that prior, after that it will be vacated. Where is that?
My
Please
lord.
show me. Please show me from the last order dated 5th of August that after rehabilitating them, then it will be evicted.
My lord,
Show me.
kindly takes up this order, my lord. This is the division bench order, my lord.
What? not the division bench. You have said
My
the
lord.
last order passed by the court.
My lord, there the state had to submit a report, my lord.
I follow that. You have
My
said
lord.
that the last order says that after you are rehabilitated, then you will be evicted.
No, my lord, that was not the submission I was trying to make, my lord. My lord, kindly, my lord, the state requires a report, my lord. We'll be rendered homeless, my lord. Kindly, my lord, allows me to at least, my lord, direct the state to appear and submit a report. Otherwise, my lord, I'll be rendered homeless, my lord. I have served notice, my lord. They were appearing now because of the change in.
The learned advocate appearing for the.
My lord, if
Yes, next.
My lord, I'm led by senior counsel Mr. Nilanjan Bhattacharya appearing for the state, my lord.
Yes. This for the petition. Yes.
I appear for the KMDA.
Yeah. What is the application for?
Lots of the application is for addition of party and or
Addition of party.
Lordship, if I may,
Whom do you want to? What is the challenge in this?
in the application, your lordship, the repetition.
Application.
In the application, the challenge is, your lordship, the KMC has conducted a hearing of demolition proceeding against my property.
How can it come under group 1?
Your lordship, I would narrate, your lordship, let me just recapitulate the repetition. This repetition was, your lordship, the petitioner's father was allotted a plot of land being such and such now in 1994. Thereafter, for the continuous period of 12 payments, they have collected all after all the payments you have got the last application I have given us
one thing.
Lordship, kindly have a look
you
with
have a
January
right.
order.
Maybe you have a right in respect of the plot. Even taking your case to that height that yes, the KMD has allotted that plot to you. That is authorize you to make construction without any sanction plan. If not, if you can construct, you challenge that before the appropriate bench.
5th January order, kindly have a look. One paragraph of your lordship's order. 5th January, second page.
One thing, this application KMC cannot be added. You cannot expand the scope of the original writ petition by way of addition of party.
misjoinder
That's
of
very
cause of
well
action.
settled. So addition is not permissible. If you want, I give you liberty to file an appropriate writ petition before the appropriate bench. Because your allegation is now against the municipality that they have issued some demolition notice. Please move before that bench.
Kindly have a look. One order, 5th January order, 5th January. That the petitioner has not come up with the answer.
Let me,
5th January order.
your lordship, let me submit for 5 to 6 minutes. My learned senior friend from KMDA has been hampering on this point forever. Your lordship, 5th January, I was directed to produce certain documents. Prior to that, I would just, your lordship, if your lordship has got the set of documents that I have handed over on the last occasion.
No, I will not hear the writ petition now. I'm only on this application. Please kindly straight away come to this application. Why do you want addition? Let me see whether they are necessary parties in this writ petition. Don't hand over documents. You have filed an application. Please.
This was previously placed.
Maybe. Please, what is the...
For showing 2 things this may be.
Nothing. Please show me why you want to plead.
Your
Please
lordship.
don't expand the scope of the writ petition in this way.
Your lordship.
Yes, what is your challenge in this? Why do you want to add?
Lordship, while giving me the plot number 141, your lordship, let me just submit. While giving me the plot number 141, in their deed of lease, permission of erection of a building was given, and in their allotment letter, after payment of all installments, there was a compulsion on the KMDA authorities to give me the possession, which they haven't done. Very well. After a period of 15 years, in around 2009,
On the senior councillor. This is Mr. Basu, you can take over.
in around 2009, they say that due to litigation, your previous plot is cancelled and you are allotted an alternate plot of FB25. That was allotted to me. I wrote it several times that give me possession advice, as they were duty bound to give me possession advice for 141. They didn't give me, they collected the payment. Your lordship has considered this point on the last occasion. Now, after 2009, several times I wrote till 2015. My father wrote till 2015. He expired. Before expiring, there was a building on that plot. Whatever it has been, there was no plan. I bow down to your lordship. I submit to that. But why it couldn't be obtained, your lordship? Because they didn't give the
Satisfy that thing.
your lordship. I'm coming right. The
Sir,
KMDA
please,
didn't
no.
give the
This cannot be expanded to that.
now one.
Yes,
more
Mr.
thing.
Basu.
Now
You can
it
take
is
over now.
respect to-
Yes.
If your lordship
Kindly
kindly.
writ petition in that way. If you want, I can give you liberty. We can, if you are aggrieved by any action on the part of the municipal authority, you can try your luck there.
Two parties, sir. One is municipal. Another party is there, but as our land allotment is concerned, there is a notice.
I take your case to that height that you have got that plot. I take your case to that height. But if you have constructed without sanction plan, or your case is that you can construct or plan is not necessary, satisfy that authority.
Cannot say plan is not necessary. Cannot.
Maybe something. So if that is, you have to move that. Mr. Basu, in this way, it cannot be enlarged.
My lord, only I repeat, my lord, this is not independent action. What I am submitting, my lord, it is if you had an independent action, corporation came fine, there is a building unauthorized, give it notice, but it's a consequence here. Order passed by your lord. On only your KMDA letter is being shown there and they initiate proceeding.
That
That's
is
why-
no. I only asked you. You said construction. I only asked you to produce the sanction plan. Only that. Thereafter, nothing I have done.
Remember, my lord is confined, you will also whether I was deprived upon payment.
That is a different thing. I will consider that.
No,
But
last time you have this is not an independent action of the corporation. It is an action taken in terms of your lordship's order, and KMDA had instigated them to initiate proceedings to wriggle out from this problem, because lordship was of the view that you settle with us. They are unable to settle, which cannot be do directly, try to now do indirectly. That's why, my lord. And there's an order by the corporation pay 81 lakhs for regularization. Well, I want the candidate for in the provision. But if the corporation is ready to do it, let them do it.
we accept that, Mr. Basu. Who is for the corporation? You are for the
No, I am for the private respondent. I am the original LOT
Oh.
prior to the petitioner.
Where is the corporation? Corporation is not here. If you accept, you want to pay that amount, regularization, you are taking that risk, Mr. Basu. No. If you want, I record your submission that you are willing to pay that cost, regularization.
Record that in view of the demand raised by the corporation, I am ready to do. That is recorded, my lord. I am no problem.
I will record only that, nothing further. I will record only your submission because I have asked you to produce the sanction plan. I will record your submission, but with regard to this, you can challenge that.
Subject to my manner which is absolutely.
Only one thing, Mr. Basu, it's troubling me. It's the question of determination, not the jurisdiction in a way. So, determination, yes. So now, that issue which you are now canvassing may be interrelated. You are the best person, you know how to, because in this matter, if I faintly recollect, there's also a writ petition in the form of a review, or review in the form of a writ petition, whatever. Yes. So even that, whether I will take up that, even I proceeded to that extent. But here is an issue you are challenging, maybe consequential.
Lordship Court has no determination. I understand.
That is
But
why
again,
I give you liberty, you can approach
again,
that.
My problem is that it is not an independent action. And it's emanated from your lordship's order. That's, if you lordshiply consider that. This is not in the, had it been an independent action, I could advise my client to go and file a petition.
So independent, you may say that some observations, they have taken the benefit of some observations. That's one way of looking at it. But here is only I have asked you to produce the sanction plan. Nothing more than that. There was no further observation. That I make it clear that you can make appropriate submissions before that. I can protect you with regard to that.
Can you for the time frame so that I can approach the authority, try to resolve the dispute.
Protect for injunction, it's difficult.
That's tantamount to my lord, entering into the determination.
Here, my lord. Otherwise, my lord, tomorrow, if possible, my lord has said then rapid action has been taken. Rapid action has been taken in council to lordship.
Not rapid.
Yes.
Well, when was my order? Not rapid.
5th
Not rapid
January
action.
order, 5th January order.
5th January order 2026, or today we are on
This is also not correct. My lord, just allow me 2 minutes. This is
No, Mr. Basu, only one thing I can do, if you can bring the corporation, then if they want, I can make those observations and I can.
My lord, this submission.
Injunction will be difficult.
My lord,
They
here,
come and make.
my lord, here kindly.
Injunction or not to whatever manner, but the situation is today is.
So this is
Lordship, kindly-
Kolkata Corporation.
Lordship, kindly hear me for a moment.
Yes.
Yeah. What Mr. Basu has submitted, perhaps this is not the correct.
See, KMD has only for us.
No. Why he is that we have instigated the KMC to issue that. This is not a fact. This writ petition was affirmed in December 2005.
It is the advocacy of a senior advocate.
Whereas demolition.
That is the advocacy of the senior advocate to impress upon the court that this relates to group one
I am
matter.
duty bound to place the correct fact. Demolition proceeding was started long back in July 2025.
All right. So, Mr. Basu,
So it is not that we have instigated
corporation-
after that order was passed.
anyone,
Yes, I can bring some. Hey.
James, you can appear. Only, where is the notice? Where is the notice?
Page 15.
Page 15 of the application.
There is for quashing of this notice. There is quashing of this notice.
Mr. Basu, it's
How
an
can it
appellable
be?
order. Demolition order. Yes.
Demolition was proceeding started in July
Comply with the order of
25.
the SOP. The order of demolition passed by the SOP 2nd of April. It's an appellable order.
Yes, appellable order.
That Mr. Basu knows.
This is not, my lord, this order, this page 16.
Mr. Basu, it's an appellable order. It's an appellable order. You have annexed this. When you have annexed this, Mr. Basu,
Along with this, page 15 is the.
maybe, yes, so direction to comply, now appeal, now your friend is here. If you say that we will approach the appellate authority, your friend is there.
No, the 2nd April, my lord, is the order.
Yes, you have time according to you.
But not served, it is along with this order. So from that date.
That's up to you, but the question of
Let us go back to the appellate.
so I'm recording that you are withdrawing, praying for leave. I do not know whether that would be also proper for me to grant.
I cannot declare how the procedure proceeds. After hearing
That's
this
the
matter, it
difficulty,
appears to
Mr.
my lord,
Basu. I do not know because
if it is in
you
this
will,
manner.
Mr. Basu, you will be difficult.
But I am
Even if that order is passed in your favor, someone may take an objection.
It may not be in my favor. What I am submitting was
No, that liberty also. If you want that you want to withdraw this with liberty to approach the appellate authority.
What I am submitting.
I can only record your submission.
30 seconds. While hearing this application, it comes to lordship's knowledge that the order of demolition has been passed, which is appealed. In that juncture, it was placed before this court that allow us to withdraw the petition with liberty to file the appeal and statutory appeal. Liberty cannot be granted necessary, but this I am praying because your lordship is allow me to withdraw this.
Yes, otherwise it will be difficulty because if I decide this on merit, either way, it will be.
Liberty may also create problem.
Fine, my lord,
Look, he is taking. Mr.
Liberty,
Basu, don't,
liberty
take
cannot.
that
If
risk.
law
I think
permits,
it's
he can
better.
do.
He's opposing. He's saying that.
If law permits, let him.
No, I think it will be
liberty is
better.
not.
Otherwise, it will be difficult.
No, liberty cannot be. Liberty is not. If law permits,
Difficulty,
he
Mr.
can
Basu.
do it.
See,
Why are you
my
taking that
condition-
risk?
My condition, see, who is opposing?
That's a different
KMDA.
thing. That's a different thing. Please, you advise your client. Yes, what shall I record? You are withdrawing this.
Let me take a step. Appeal file को stay नहीं, that is the first appeal data.
Liberty to take appropriate steps. I am not saying anything.
If law permits, in accordance with.
No.
Hey, Bosun, কি হচ্ছে? Yes, Mr. Basu, please tell me.
But if I can put in this way before, why not subject to my landlord's concession, not recorded, that for 2 weeks, till I file the appeal, they have not taken steps. Understood. My landlord can.
Yes, what do you say, my lord? You have not heard Mr. Basu.
Actual one. Because this is the actual one.
He says that, can you assure that he will not take any steps? It's difficult. One way you can, then you can approach the writ court for that that you can do, Mr. Basu. What do you want? To appeal or the writ court?
Better, my lord, liberty to withdraw, with liberty to move afresh in accordance. Wherever I will go.
All right.
No.
This is an Please survey copy. Since the corporation has not yet been implemented as a party, no copy of the application for addition of party was served upon the proposed parties to be added. The learned advocate appearing who usually appears for the Kolkata Municipal Corporation is present in court today and is requested to appear in this matter. Let his appointment be regularized by the concerned authority. The learned advocate on record of the petition is directed to serve a copy of Can 1 of 2026. You only want the Can of 2026 upon him in course of this day. Please do it. Yes, next.
I'm grateful, my lord.
In matter, what is that? Yes, next.
Your lordship has made the writ returnable.
It was appearing.
It was in a monthly.
Yeah. Yes. The
Pay for the review applicant, my lord.
the review petition and the connected applications. Item number 2. For all the reasons that the apostle Thank you.
But I only express my sincere gratitude, my lord, for my lord's kind wisdom to hear, my lord, all of us.
Always.
And my lord has also made it very clear that my lord is only to the maintainability.
Yes, I've only.
Yes, I've heard.
I've not said not maintainable. I've said not entertain.
Not entertained. I've heard and followed, and lordship have made it very categorical that nothing has been touched on the merits. Not even only the entertainment.
Yes, because if I have not entertained, I cannot enter into the merits. So only on that ground.
Extremely good.
Thank you. Yes.
If
Mr. Chatterjee is online.
Yes.
Sir, I'm online, my lord. My video is not working, my lord, but your lordship has heard this matter, my lord, at length.
So if your video is not working, Mr. Chatterjee, I cannot. Take your submission,
There's a
Mr. Chatterjee.
camera glitch, my lord.
Yes. Please.
My lord, this application
Yes,
was
you are for the state. Yes, what is the instruction?
I'm led by Mr. Trivedi.
Yes. Yes, Mr. Trivedi, what is this?
Lordship, ये आपका copy. ये photo है. Petition का copy. Lordship, I will kindly appreciate these things. Here, my lord. First of all, my lord, my instructions are, they are not in possession. As if they are saying that as if they are in possession, this is a forest.
If you are not in possession, there's no question of eviction then.
I'm coming, my lord. My lord, kindly.
Allow me.
Mr. Trivedi,
I will come to that fact, but my lord, if my lord does not understand from me, my lord, what is our case, my lord, then my lord will, my lord, because they are just reading in piecemeal. Now, lordship will kindly appreciate, this is the situation of the land as on today. If to my lord, if allowed to file an affidavit, we'll put. Now, these, the petitioners have gone and, my lord, this is what they have done. These are some pillars on the forest land they have. Now, this is the position today. Now, lordship will kindly see this particular case has a checkered history because once upon a time, what they are claiming their right and title.
Only one thing. Mr. Chatterjee, when have you fixed these pillars?
No, they were there forever.
Does not appear to be so.
No, they were there forever. We were doing mining business from there with a mining license.
Sir, that's a different thing. Pillars, when we have erected.
But that at present, Lord, it doesn't really, in my respectful submission, go into the root of the matter. But I will take instructions if your lordship wants when we've erected the pillars. It is not about erection of the pillars in any manner whatsoever. Seize the notice, Lord.
All right. Yes, I will come back to you. Yes,
Now,
Mr.
lordship will kindly appreciate. Now, my lord will kindly appreciate just 1 minute from my lord's. This is the note. And lordship. Now, my lord, just 1 minute. What 1920? What they claim from the writ petition? 1920. This particular plot of land, which included a larger land, was purchased from the erstwhile owners from Maharaja of Bardhaman. That was in 1920. Now, lordship, then 1960, there was an order of this honorable court asking the take appropriate steps for the state government. For innumerable number of days, since the laws have come to being in India after independence, this particular land has been recorded as a forest. In RS records, they could not. Then, lordship, what happened is, now in 2018, as far as plot number 406 is concerned, they have taken 406. Only 406 is concerned. They have taken lease, sublease from the lessees. Now, by virtue of that sublease taken from the lessees who have got a lease in 1920 from the Maharaja of Bardhaman, lot of water has flown under the bridge. Now, lordship, when the matter came before your lordship, initially, my lord directed consideration as to whether they are lessees or not. We considered all the letters, which is marked as annexures. And we said there is not a single government record. Lordship will kindly come to page. The notification, the notices which they have challenged, 135 is the first one.
From the petition?
Yes, Lordship. They have challenged 3. 135, 136, and lastly 137, which Lordship was saying about 33 1A.
Yes.
My Lord will kindly just allow me. Now, my Lord, 135, my Lord will kindly see. We, as per my Lord's order, we considered all their documents and we came to this finding. First of all, my Lord, one I can read with my Lord's permission, my Lord. They narrated their statement from lease agreement of 1920 to the Honorable Court's verdict on 28/4/60. That is, my Lord, the first time they came before this Honorable Court, but failed to produce any government order regarding lease in consonance to the verdict dated 28/4/1960. Also failed to produce lease khatiyan in favor of the above land schedule. Nothing submitted adverse to RS and LR records of right, which is in favor of the Forest Department. They have challenged present ROR, means records of right, of so-and-so Mauza in the office of the ADLRM Paschim Bardhaman, which is made known to me without serving a copy to the undersigned. Based on the above hearing, it can be stated that the mayor challenging a record of right could not dispute the right over a plot until contrary is proved. Hence, as of now, right over LR plot number 406 of so-and-so Mauja, west on the Forest Department, as long as the records of right of RS and LR Khatiyar in favor of Forest Department prevails. The above finding is submitted for your kind perusal and necessary directions regarding the matter for eviction. Now, Millers will kindly come to eviction. Lordship will kindly see, we have a right, if anybody comes, 31A, my lord, this is, my lord, 33(1)(a).
You have a copy of the forest act.
33(1).
Please give a copy of the forest act.
Lordship, I am giving mine. एक second देखिए नहीं करो एक second. No. Lordship, this is the manual. It has eviction. That is why I was seeing.
Right of eviction is there.
Yes, my lord. That's why I got it. 33(1).
amendment is there.
हमारे पास जो अभी, my lord, I am also new to this law. Therefore, I got the book. 33(1)(a), my lord. Therefore, my lord, I got it right from the department. Because, my lord, I am also new to this particular branch. So, lordship,
please give your book.
Now, my lord, therefore, my lord, I got that book, my lord, because
State amendment, my lord. This is that page.
Because this is the question which was perturbing me, and I asked my officers yesterday, my lord, and I wanted this book, my lord. Now, my lord, स्टेट अमेंडमेंट कुछ अलग है क्या?
ना
अलग है ना আমি জানি না আমার তো ওইখানটায় লেখা আছে ওই জন্য আমি report also which I submitted by my lord before my lord, my lord. If my lord kindly takes my report, ये नहीं है. Lordship will kindly take my report also, my lord. Submit করেছে? দিচ্ছি ওইটা annexures দিয়েছি, my lord.
Oh, report has been filed.
No,
by
my
you.
lord, the annexures have been given by mistake. The report which was forwarded, my lord, duly signed by the officer. দিচ্ছি এক মিনিট দাঁড়াও. My lord will kindly see the first paragraph, third paragraph.
Sir, Trivedi, please give me one.
I apologize, lordship.
Yeah. Mr. Trivedi, I was mistaken. Their book is also there.
State amendment. State amendment. Well, that's there, but subject to
State
correction.
amendment, this will apply to.
No, certainly it will apply. Well,
the last occasion you have not pointed out to.
No, well, that was there.
I was also
No,
new
no,
to this
but
law. Forest
just
matters
may I
I've never
put
done in my life. So
No,
yesterday,
no.
Millard, therefore, Millard.
May I most humbly, Milord?
Yes.
May I most humbly?
Yes, Mr. Chatterjee, I will hear you. Yes, Mr. Trivedi.
Now, Millard will kindly come to the report, and along with that, Millard, I have given a list of documents for my lord's perusal of the department, from which lordship will kindly ascertain that this is all through a land which is. Lordship will kindly come to page 7.
135.
Which forms part of page number 135. But I am going through my documents, my lord.
Your documents, yes.
My lord, 406 is there. In the RS plot also, it is recorded as a forest land. And in LR also.
Yes.
Now, lordship will kindly come to page 10. Enclosure.
Of your,
No, of the lordship. My lord will kindly see this is the notification which includes Government of West Bengal, Department of Forest. If my lord kindly flips over the page and comes to page 11, my lord will kindly find that 406 is the plot which is there. My lord, page number 11, lordship.
Yes.
1, 2, 3, 4, 5, 6. Sixth row, my lord, column 406.
127.46.
Lordship. Now, my lord, it is, and my lord will kindly allow me to place whatever documents my learned friend has placed by way of writ petition. These are vis-a-vis, my lord knows, my lord, I need not say. We, as registering authority, if I buy a property without due diligence and a person sells it to, and where they are deriving their title, lordship, 1920.
Mr. Trivedi, page 10, what is the date, exact date of the notification? Because the right-hand portion is not there. 14th of October 20.
No, my lord, it is not, it is our page 10, lordship. Yes. This is, my lord.
What is the date?
I'm just going, my lord, it's 14th of October 2025.
2025, because 5 is not appearing.
No, my lord, I apologize, my lord, while,
Alright.
my lord,
So
now,
2025.
but my lord, it is not that, it is a land which has come within the ambit of Forest Department in 2025. But my lord, it is since innumerable number of days, because my lord, from the documents also, which have been annexed by them, they were wanting the records, right of records to be transferred in their name, which has never been, right from time immemorial. They had purchased the property, which was not mutated, or the records of right were not in the name of their erstwhile purchasers. And whatever happened in 1920 with Maharaja of Bardhaman, lordship, that cannot be relied upon at this stage when, lordship, we are in 2026. And they have purchased the property in 2018. They ought to have seen the records of right.
Have they applied for?
They have made an application, lordship, before the BLLRO. What I could understand from the reading of the lordship will kindly come to their application, which is at page 121.
Yes.
This is appeal.
Appeal. That is pending. That is your document.
Yes. What happened to this?
That is pending according to my instructions, lordship, which we have given to your lordship.
So this is an appeal. Where is the original order of the authority?
That has not been supplied to us. That's why, my lord, we had to
You have preferred an appeal.
Yes.
Without that order, how could you prefer an appeal?
Because they could not provide any.
Respectfully submitting, this will not probably go that way. If your lordship gives me 2 minutes to what Mr. Trivedi has told your lordship.
Yes. Yes, Mr. Chatterjee.
Lord, with a lot of respect to Mr. Trivedi, Lord, I think he has forgotten civil law completely. Lord, what has happened is in
That is true, my lord. That is true, my lord. I really agree with you.
If a court has declared that the property, that the lessee will become a lessee, it is not for the record of rights to, my lord, take away that right which is given to me by court. My mutation or recording, my lord, is rebuttable. That rebutting, my lord, is the court's order. He says, since I've got a court order in 20, it is not valid in 2026. From where, my lord, may I ask this question to myself? He gets this law. It's been declared to me, my lord, in 1960. He says it's not good law in 226.
No, Mr. Chatterjee,
never challenged it.
you have challenged the wrong recording of the record of rights before the authority.
You know, that's a different aspect altogether.
Where is the
I
order
am
passed
saying,
by the authority?
forget about it. Milord, I am saying, Milord, record of rights do not take away my title given to me by court.
Mr. Chatterjee, that's one way of looking at it. Please show me
Milord,
the order
kindly
passed
look
by
at
the
that
authority.
way, only in that way.
Yes, please show me the order of the authority.
Milord, the order
We
of
have
the
not been
authority, Milord,
supplied.
is not with
That's a
us.
specific
It has not
pleading,
been
Lord.
supplied to
preferred an
us.
appeal.
That is why we have preferred an appeal. That is why. It is not for anything else.
RTI document, my lord, we have nothing.
Looks to the RTI document, Milord, what Mr. Trivedi submits is
only one thing.
extremely, Milord, without law.
You have issued an order of eviction. Now he has challenged. So if you want to file a report on this,
But I will.
in the meantime, if you take then this.
No, my lord, it is. My lord will kindly appreciate.
Instructions.
It is not that he has butted and bounded, or rather delimited that portion by walls. Today, what therefore I got today's photograph, it is just that they have planted certain pillars there. My lord will protect the forest department also. If, because it's a land where we are not doing anything, but any further construction if they make
No, that's
on the
fine.
basis
I
of
agree
this,
to that. That is something I will
on
not,
the basis of
disrespect.
this, my lord, because and my lord will give them,
Mr. Chatterjee, don't make any further construction.
because my lord
No,
they
no,
are
we shall not
constructing
make.
on it,
We
my
shall
lord,
not
you
make.
see. And my lord, and lordship will give a very limited stay, my lord, because and I will come up with the affidavit because
May I, my lords, kind leave, my lord.
I've not seen you, Mr. Chatterjee.
My lord, I'm always before your lordship, my lord. Your lordship knows.
Your name is only appearing.
my lord, he's
That
angry
is what it is.
because I have made him, my lord, appear. He's angry with me today.
No, thank you for making me appear. What are you saying?
My lord, with this antidote to the whole proceeding.
The petitioner has challenged the
Grateful, my lord.
notice
I'm grateful. May I take
So
back the
এখানে
book?
না, shall not make any, shall also not change the name.
Rising
এই পাশে চলে এদিকে।
Lordship, before rising, may I get
Because I learned this law little bit.
may I get your lordship's kind indulgence to mention one matter? Your lordship has fixed it yesterday. Your lordship, the list collapsed. Your lordship, I could not appear today. It's running in the list, item number 97. Your lordship.
97, what is the urgency?
Your lordship, urgency is the same. Your lordship, the BLRO may demolish my premises. Your lordship. I'm residing there over more than 80 years. Your lordship, and your lordship, the petitioner was seriously ill and was admitted in the hospital, your
Who is
lordship.
appearing for this? Mr. Trivedi is appearing.
Yes, your lordship,
Mr.
that's
Trivedi,
right.
what is this?
My lord, it is, we have got the entire instructions, my lord.
Yes.
It's a vested land, lordship, where they came and they, my lord, they are making construction. I have got photographs and everything. Now, my lord, they are coming and coming before my lord without, and the documents by way of supplementary affidavit, because they have, it does not give any right or.
Well, tomorrow I'm keeping it at the top.
Lordship,
Okay.
will kindly appreciate, yesterday it was there, she did not turn up.
Your lordship, the
I
list
was there.
the list was collapsed suddenly. Your lordship, kindly keep it at 2 p.m. Your lordship, if your
কেন হবে ভাই আজকে
Tomorrow, Mr.
Yes, my lord, I shall be.